All right, I want to step away for a second and bring in our guest for this hour. Joining us, national trial attorney Mike Jaafar. Michael, great to see you. Thank you so much, as always, for joining me here on the program. And, you know, as I listen to this testimony, it just saddens me. It angers me. And I would imagine that's exactly the reaction that this prosecutor wants from the jury.
100%. This is giving him the momentum he needs. He's thoroughly discussing the jury with the defendant. It's exactly what the prosecutor wants, the prosecutor needs. These prosecutors around the country have made a decision. They've made a decision that's actually going to shift the society on this whole entire gun issue and what happens. And you're seeing it play out here. If you're a parent and you're going to give your kid a gun, this is the message they're sending. This is what you can expect to face if your kid goes off the rails. And this is exactly what you're seeing play out.
So talk to me, Mike, and I agree with you. It seems to be a bit of a trend. I know in Georgia, it sounded like from the opening statements and the way the law is written there that they have to show that he knew, not that he should have known, but that he knew that his son was going to do this. Now, it's problematic that he gave him this gun under the circumstances, but he was trying to help. I think his case is distinguishable a little bit from the Crumbly's in the fact that he seemed much more involved in the entire process than his parents did. But what are the key factors in a case like this, Mike? What are they showing? They're showing maybe, are they trying to show his indifference? Are they just trying to show that he gave him a gun and he knew that the kid had mental health problems? Or do you think there's more needed here in a case?
No, I think when they looked at the facts, they said, look, you knew your kid had a shrine to the Parkland shooter and he worshipped the Parkland shooter and he had deteriorating mental health and you intentionally gave him a gun. I think that they are just throwing this fact pattern out there and saying, let's see what happens. I think they have enough there to discuss and thoroughly discuss the jury and say, if you're a reasonably prudent person and you know that your son, imagine having a kid who worships a school shooter. That's this guy's reality. So,
Mike, let me ask you a quick question. I'm sorry to interrupt you. I want to ask you a quick question about that. Because as I thought about that yesterday, you and I, we were here for that case when it went to trial. Our watchers may know who the shooter was in that Parkland case. But do you think the average American would know who he was? If you showed him a picture of the guy, so let's say this guy had a shiner, he had a picture of the guy on the wall, the young guy, and he goes in the room and he sees the picture up there. Do you think he would know that that was the Parkland shooter?
I didn't think about it until you just said it. You know what? Yeah, I assumed that he would know, but you know what? That's a good point. Maybe he didn't know. And maybe he didn't know. Maybe he had no idea who that person was. And if that's the case and he didn't know, then I give that back in his favor that, hey, I had no idea. He might have been kids worship rock stars, they worship athletes. I have no idea. So that I don't know. It does matter, actually. It really does matter, and I'm interested to see what happens with that element, because that is important, in my opinion. If he knew that it was the Parkland shooter and his son was worshiping him, I think he's guilty of the charges of at least involuntary manslaughter. Yeah, but if he didn't know, I would change my mind.
Yeah, I would agree with you there, Mike. And also, it sounds like we both think he needs to testify. But we'll get on that in a second.
Yeah, 100%.
Right? 100%. All right. We'll get to that in a minute, Mike. I do have to take a break here, folks. When we come back, we'll have more key testimony in the murder trial of Colt Gray. So keep it here on Court TV. All right, let's bring back in our guest, still with us, national trial attorney Michael Jaafar. Michael, with all of these witnesses, these young witnesses, we're not seeing any cross-examination. That's certainly the right choice by the defense, isn't it?
100%. I wish they would stand up and just tell him something, nice and kind. And yeah, I'm sorry for everything that happened to you. You're very brave for testifying today. I mean, that's a missed opportunity for the defense. I think the defense should do that. But yes, definitely no cross-examination. Now, we talked a little bit about the defendant taking the stand. I think that's clear. I mean, if you're talking about a case where this jury needs to know what he knew, right? He's going to have to go up there and tell them what he knew and be credible in doing so. But other than that, what do you think the job of the defense is here? Obviously, putting him on the stand, job one, but what else do you think they need to do? The job of the defense here is very, very important. It is to put him in line with the people in the jury and the people and the victims and the people who are in the courtroom supporting the victims, that I cannot believe this happened. I wish it were me instead of these victims. That's the job of the defense. If I was his attorney, I'd be preparing him for trial saying, we have to let the jury know that you wish it were you, not the kids and the people who died. That's their job overall.
Now, when we talk about what he knew and what he didn't know, one of the things they talk about in opening statements is there are a series of texts between him and his son, and what they say the texts are going to show is that the son was being deceptive, which I think juries can sort of relate to because teens can be deceptive.
Yep. Yeah, 100%. Because, and that's in line with making him seem like somebody who is just as baffled as everybody else. And he also feels that, this is a tragic thing for all of them. So I did not know. He was 14 years old when this happened. But before he was 14, he was 13, he was 12, he was 11, he was developing, he just hit puberty. He was being, I didn't know, I'm not equipped. I did not think I had a school shooter living with me. And I didn't think, no one would read into deceptive text messages with their 13-year-old, 14-year-old son that they're about to shoot people and murder them. So yes, I agree.
That is the last thing anyone thinks about their child. And I'll said that during the Crumblies, and I'll say it again. Mike, thank you so much for joining me this hour. Truly appreciate it. Folks, we're going to have to squeeze in a break here, but when we come back, we'll bring you more key testimony in the murder trial against Colt Gray. Keep it here.